Hello everybody and welcome to Legal Studies Unit 3, Area of Study 1, the Criminal Justice System Part 6. The focus of today's video will be dot points 11 and 12, fines, community corrections orders and imprisonment and their specific purposes, and factors considered in sentencing, including aggravating factors, mitigating factors, guilty pleas and victim impact statements. I just wanted to bring to your attention that I will not be looking at the factors that affect the ability of the criminal justice system to achieve the principles of justice, so costs, time and cultural differences, as well as recent and recommended reforms, since I'm well aware that each individual teacher is likely to have a set of recent and recommended reforms which they think is best suited to their class. Specific purposes of fines, community corrections orders and imprisonment. Fines. A fine is a monetary unit to be paid by an offender to the state for breaking the law. A fine is issued in an attempt to punish an offender for breaking the law and deter them specifically from committing the same offence again. Fines may not be as effective in deterring the community as they are not publicised by the media regularly. A fine may not punish nor deter an offender from committing the same crime if the offender is wealthy, for example, and is not bothered by the fine. On the other side of the spectrum, fines may fail to achieve their purposes for some population groups. For example, homeless individuals may not have the means to pay their fines and may end up in prison. Community corrections orders. A community corrections order is a flexible, supervised sanction served in the community that has different conditions which are suited to the needs of the offender. This non-custodial sentence can only be imposed if the offender has been convicted of an offence punishable by more than 5 penalty units, the court has received a pre-sentence report, the offender consents to the order, and the court agrees that a community corrections order is suitable for the offender. A pre-sentence report needs to be received from Corrections Victoria to assess if a community corrections order is suitable for the offender. It may include the following information about the offender: their age perhaps, their education, employment history, their financial circumstances, and even any history of drug or alcohol abuse. The length of a community corrections order. 2 years if the offender is sentenced in the magistrate's court, or no more than the maximum jail term if sentenced in a higher court. There are core conditions that are attached to a community corrections order. The offender must not commit another offence punishable by imprisonment during the term of the order. The offender must report to a specified community corrections centre within 2 working days of the order coming into force. The offender must report to and receive visits from a community corrections order officer, and the offender must notify an officer of a change of address. The offender must also not leave the state of Victoria without permission, and they must comply with any directions of the community corrections officer. There are also special conditions, and every community corrections order must include at least one of the conditions. These include working up to 600 hours of community service, agreeing to have treatment for drug and alcohol use, accept supervision or management by Corrections Victoria, stay away from a particular place, stay home between particular hours, stay away from licensed venues, go back to the court so their program can be monitored, or pay a bond which will be forfeited if they fail to comply with the community corrections order. Some examples of community corrections orders include disaster recovery and graffiti removal. Rehabilitation is at the core of community corrections orders. They are all about introducing the offender back into the community and preparing them for life after they serve their community corrections order. Imprisonment. Imprisonment deprives an offender of their liberty by removing them from society. Imprisonment is often referred to as the sanction of last resort. Imprisonment protects the community as the offender is in prison. The only time this may not be the case is if the offender is on bail and decides to reoffend, or if the offender escapes prison. The offender is punished as they are deprived of their liberty. However, for some offenders, they may not see prison as a punishment as they are provided with a roof over their head and a meal every day. Deterrence. Offenders may be deterred as they do not want to be deprived of their liberty. This may not be the case for recidivists. Others in the community may also be deterred from committing similar offences as they may fear spending time in prison. Rehabilitation. Prisons usually have programs in place to try and rehabilitate offenders, for example, drug-alcohol programs. However, some offenders may not be willing to participate in their programs, or there may be a long waiting period. Factors considered in sentencing. Aggravating factors. Aggravating factors are factors that increase the seriousness of the offence and therefore the offender's culpability. The offender is likely to receive a longer sentence. Some examples of aggravating factors include if the offence took place in front of children, or if the offence occurred while the offender was on a community corrections order or on bail. Mitigating factors. Mitigating factors are factors that decrease the seriousness of the offence and therefore the offender's culpability. The offender is likely to receive a shorter sentence. Some examples of mitigating factors are if the offender was provoked by the victim, if the offender shows remorse, if the offender cooperated with the police, and the young age of the offender. Guilty pleas. Guilty pleas can reduce the sentence if made early. Guilty pleas encourage the offender to plead guilty and therefore skip trial. So why is a guilty plea beneficial? The first reason is that early guilty pleas save the time and the resources of the court as there is no need for trial. The second reason is that early guilty pleas prevent the victim and their family from having to go through the trauma and stress that is associated with having a trial. Victim impact statements. During sentencing, the court must take into consideration the impact the offence has had on the victim. A victim impact statement allows for the victim to express how they have been affected by the offence, their personal circumstances, as well as any injury, loss, or damage resulting directly from the offence. That concludes today's video. I hope that your knowledge of dot points 11 and 12 from Unit 3 Area of Study 1 have been consolidated. If you do have any questions, feel free to leave them in the comments below or send me an email. Thank you.